Immediately, an inspector can walk into a consumer business. This new law doesn't cover natural health products. This Consumer Product Safety Act is directed towards consumer goods. But an inspector could walk into any business dealing with consumer goods, whether you're a retail manufacturer, distributor, whether you're just shipping them, and basically seize them on the spot. They can seize your building. They can seize your truck. Do they need a court order? No. Do they have to report it to court? No. Which is kind of interesting, actually. The police, our regular police, in some situations have the power to seize without a warrant. I mean, if they pull you over and there's a bag of marijuana in the passenger seat, they don't have to apply for a warrant to seize it because it's in plain view. But even then, the police have to report what they seized to a justice within 24 hours and then ask for a court order, ask for permission to continue to hold it. Otherwise, they have to give it back. Because we've learned the hard way over the years, you cannot allow the state to take property and not have it supervised. Otherwise, then we're in tyranny, aren't we? So, just by definition, I don't mean to alarm anyone or be sensational, but it's just, that's the fact. So, but under this new law, if they seize your property, no, they don't have to report it to a court. There's no requirement at all. And there's no time limit on how long they can hold it. The only way they have to give it back is if they've seized it for non-compliance, and they can seize it for other reasons, and you can show you're in full compliance, then they have to give it back. But we know under the Food and Drug Act there's a similar power which is being challenged in court and a similar provision. And I'm just not aware of them ever giving property back. Like, in my career, I've never seen it happen. I mean, maybe it has and I don't know about it. So, but under this new law, if they seize your property, no, they don't have to report it to a court. There's no requirement at all. And there's no time limit on how long they can hold it. The only way they have to give it back is if they've seized it for non-compliance, and they can seize it for other reasons, and you can show you're in full compliance, then they have to give it back. But we know under the Food and Drug Act there's a similar power which is being challenged in court and a similar provision. And I'm just not aware of them ever giving property back. Like, in my career, I've never seen it happen. I mean, maybe it has and I don't know about it. Under this new Consumer Product Safety Act, the state can also, in some circumstances, keep your property. Like, it becomes their property without a court order. Of course, under this new act, the minister can order a recall, where before they can't. And in fact, this one is particularly galling to me because how misleading it is. And it's been the main talking point of the government for the bill. Almost every time the Minister of Health opens her mouth to promote the bill, she says, you know, if there's a dangerous product out there and the manufacturer won't recall, Health Canada currently doesn't have the power to order a recall. And that's really misleading. And here's how it's misleading. It's true. They don't have the power to order a recall. But it's misleading, because when you hear that, when the average Canadian hears if there's a dangerous product and the manufacturer won't recall and we don't have the power to order a recall, we think they don't have the power to protect us. And that's the message we're supposed to get. It's supposed to generate fear in us. Oh, they can't protect us if a manufacturer won't recall. Well, what's wrong with going to a court and getting an injunction? Court order ordering them to recall. What's wrong with that? What's wrong with getting a warrant and seizing the product, solving the problem? What's wrong with the ministerial order? If there's a significant danger, you can make a ministerial order. Oh, I know what the problem is. All those things adhere to the rule of law. So first, your court orders. You've got to go to court. And the court's going to supervise everything. The ministerial order under the Hazardous Products Act, it's supervised. It's got to be tabled in Parliament so everyone can see it was made. It only lasts for 14 days unless the Cabinet confirms it. And do you understand why that's a safety thing? Is it allows the minister, if the minister's unsure, because an inspector could be on the spot and not be sure, well, they can, as a precaution, take control over the property, but it expires if after 2 weeks they realize, oh, it actually wasn't a danger, we can just let it lapse. And if they do confirm the order, the property owner can apply to a review board that has court-like powers. It's independent. So you see, all of that adheres to the rule of law. It protects us if there's a safety risk, but it adheres to the rule of law, and it's all done in the open. All that's changing is that now it doesn't have to be independently supervised, and it doesn't have to be in the open. It can be done in secrecy. Now, this is really important for you to hear. In Canada, because we're a liberal democracy, we realize if we give order-making power to some person or some body, we have to be able to see how it's being exercised. And there has to be kind of some review. And so we've got what's called the Statutory Instruments Act, which provides that if somebody makes an order under an Act of Parliament, they've got to send the order to a clerk. And it's published in the Canada Gazette so everyone can look at it and go, oh, that's how this power is being exercised. It's out in the open. And then there's a committee that looks at each one of these tabled orders and just asks, does it unduly encroach upon the Bill of Rights or the Charter of Rights and Freedoms? And that way it acts as a check. But under this new Consumer Product Safety Act, for your protection, orders like ministerial orders ordering a recall or inspectors just taking control over the property, that's exempted from publication. It's exempted from the Statutory Instruments Act provisions. Does that make you feel safe? So we're undermining the rule of law. I mean, political philosophers would tell us one of the most dangerous things a society can do is allow the state to act arbitrarily. And not only are we doing that, but we've got a provision in there so it can be done without publicity, without scrutiny. And it really kind of raises the question is, does that make you feel safe? Now, let me tell you how it would play out for this company. Because we know Health Canada wanted every one of these sold for 13 years off the market. We know that because they demanded the company recall every one they've ever sold. Now, under the old law, what happened is Health Canada made this demand. The company got a legal opinion that said, there's just wrong in law. Like, if they have a problem, Health Canada can go to court. But Health Canada is not going to go to court because they'd be embarrassed, right? Like, could you imagine going in front of a judge and saying, I need an order to take this because it's got table rice in it off the market. So they haven't. But if there was a risk, they could. But now, here's what I would do if I was an inspector. I just sat down and I said, okay, I'm a Health Canada inspector. I know I want this product off the market. What would I do personally? And so what I would do is I would show up at the company at about 2 in the afternoon. Now, I would pick that time. I don't want to show up in the morning before all the managers show up. I don't want to show right up after lunch in case there's an executive lunch happening. I want every decision maker in the company there because I want to protect Canadians. And I will serve them with a ministerial order ordering a recall. It's a binding order. It's not a court order, but it's a binding order. It's an offense not to obey that order. And I would also, as a term of the order them to take out full-page ads in the 2 national newspapers for a full 2 months. Because a recall means nothing unless it's public and everyone knows, right? Binding order, it's an offense not to follow this order. Not a court order, but it's a binding order. Now, you're the managers. This Health Canada inspector has taken his or her time and explained the order to you, and they leave. You're in a panic. Because you all know, if we follow this order, the company's out of business. And so you phone your corporate lawyer. Now, you don't get to talk to your corporate lawyer because it's late in the day. I can tell I'm a lawyer. Sometimes we're in court. Sometimes we're at meetings. Sometimes we're just out of town for personal reasons or whatever. And sometimes we've got so many fires, we can't get to you that day. So they don't get to talk to their corporate lawyer on day 1. They at least stop filling orders because they're spooked. So new orders that come in, they're not filling, but they have not recalled. Day 2 rolls around, they're able to talk to their lawyer, and their corporate lawyer, like most corporate lawyers who know nothing about consumer safety, they incorporate and they do contracts for you, goes, gosh, I don't know. I don't know if you have to follow this. I'm going to try and find a lawyer who knows, or I'm going to have to do research and I'll get back to you in a couple of days or a week when I can. I understand it's an emergency, but that's how it works. So on day 2, they don't do a full recall, but they at least call the stores and say, can you send us back the stock you have? We're having a problem, and off we go. Day 3, they're still waiting for a legal opinion. Now, I'm the Health Canada inspector. I'm really angry because this dangerous product is still putting Canadians at risk. So I show up, and they've defied a ministerial order. Okay, no, these people do get angry because they think that when they say jump, you have to say how high. So I show